SJC-11695, Commonwealth versus Vazquez.
Ms. O'Brien, good morning.
Good morning, Your Honors. Leslie O'Brien for Mr. Vazquez. May it please the Court. If I may, I'd like to address first the second argument in my brief, which concerns what I'll refer to in shorthand as the Augustine issue. The defendant has argued that his counsel was ineffective in failing to move to suppress the CSLI that was introduced against him at trial, on the ground that was introduced without a warrant and without probable cause. However, I'd direct the Court's attention in particular to the second part of the argument at pages 37, I believe it's page 37 of my brief, where the defendant argues in the alternative that even if he's not entitled to the benefit of Augustine due to the finding of non-retroactivity, the application in support of the application that was submitted to obtain the CSLI was insufficient even under 2703D.
Can I, before you go there, can I just make sure I understand what you're saying on the ineffective assistance in Augustine? So Augustine says in order to get, it's not retroactive unless you preserve the argument, right?
Yes.
And then you say, well, we still have an ineffective assistance claim based on this footnote 9 in Broome, right?
I did rely.
So I'm just trying to understand
Broome, yes.
what the status of the law is then. So if you preserved it, you get it retroactively, Augustine, but if you didn't preserve it, you still have the ineffective assistance argument, right? And I'm just trying to make sure I understand what world we live in then. So you win, you have that, you've either preserved it or you have it as an ineffective assistance claim.
Well, not exactly. I'm not saying that would be so in each and every case. But I'm suggesting that every case would need to be looked at individually. Mm-hmm. And if you have a case like this where the application is clearly very carelessly drafted, that should have alerted counsel, where the evidence was very important to the case.
So it's not in every case?
It's not in every case, no. I'd suggest that it would have to be an individual analysis by the court to determine whether, in the particular circumstances of the case, the ordinary fallible lawyer would be alerted to the fact that there's something wrong with this application, and it should be challenged. And so,
I mean, even if you needed probable cause, the affidavit, as I recall, said that a named informant, Derek Rodriguez, had said that the defendant had admitted to the killing, that the defendant asked him to hide a gun, and that they had independently determined that Rodriguez had 2 phone calls with the defendant, indicating that he had some relationship with the defendant. Would that not be enough for probable cause, even if it was needed?
It's enough for the first part of probable cause, and what I'm asking the court to focus on really is whether it establishes the second part, which would be that there would be a connection between the records that were sought in the application
Records are
and the crime.
CSLI. I mean, wouldn't it be relevant as to whether or not Mr. Vazquez was at the scene of the killing at the time of the killing?
Yes, yes, it's definitely relevant. I don't think I've stated that would not be relevant to that question.
So how do you win on this?
Well, Your Honor, what I'm stating is that if the court does not find that this is, in this particular case, the state of the application should have alerted counsel that there was something very wrong here. After all, we have a situation where at one point in the application, the wrong person is named, Gonzalez. The person, it's obvious that the person who wrote up what I'll call the affidavit in the application, it's signed by someone who obviously did not write the affidavit. It's an unusually poor job. But there is, I've certainly conceded that there is this evidence, that there was this claimed evidence through an informant who was lassoed by one of these buy-bust situations into testifying, and he gave this information. He claimed that Mr. Vazquez, he claimed that Mr. Vazquez admitted to the crime. So you have that much. But even under 2703D, my alternative argument is that under 2703D, there was required to be a showing of specific and articulable facts showing that the records sought are relevant and material to the crime. All you have here is the claim that there was cause to believe that Mr. Vazquez was the shooter, and that he had a couple of phone numbers. That's it. If that's all that's required under 2703D, that makes this, it contradicts the requirement that there be specific and articulable facts.
But I thought we also have, again, we also have that that one of the witnesses says that he's asked him to dispose of the gun, right?
Well, yes, but that doesn't get us to.
And that's the person whose phone we're looking for? We're looking to...
No,
We're looking to connect that person with the defendant, right?
No.
No, we're not?
No, not at all. There's nothing like that that's stated in the application. All that the application says is, basically, we have this cause to believe that Mr. Vazquez is involved in this murder, and we have information that he had a couple of phone numbers. So therefore, according to the procedures that were followed here, that was enough, that there didn't need to be, under 2703D, any showing that the phone records would be relevant, that the CSLI would be relevant. There's not even, the affiant doesn't even take a stab at that.
SLI plainly relevant as to whether or not he was at the place of the killing at the time of the killing?
Well, no, because there's not even the mere fact that he owned a phone. There was not testimony that he had either of those phones with him. There was not testimony that anyone else was involved in the shooting that he might have been communicating with. I'd suggest that the reasoning of White is applicable here.
This is a D order, right? It's just reasonable. This is just reasonable suspicion, correct?
Yes, reasonable suspicion or specific and articulable facts that the records are relevant and material. And there's just not even an attempt by the affiant to say that these phone numbers are in any way relevant to the shooting. There's no evidence that that the defendant was communicating with anybody else at the time, that he even had either of these. There are two different phone numbers that are given. So it's basically a fishing expedition that maybe one of these phones might have had some relationship to this homicide.
I'm just looking. Rodriguez permitted police to view his phone contacts, which listed two numbers for the defendant. These were the numbers the defendant was reportedly using at the time of the shooting. CSLI associated with those numbers from June 18th, quote, may reveal the general location of suspect Vazquez at the time the victim was shot. I mean, that's not enough?
No,
Especially when
Your Honor.
we have multiple eyewitness identifications of the defendant as the shooter?
If that's enough, then all that's needed under 2703D is cause to believe that the defendant committed a crime and information that he owned a cell phone. And I'd suggest that I realize that Commonwealth versus White deals with probable cause, but there was much more in Commonwealth versus White to connect that phone to the crime. There was the fact that there were multiple individuals involved, raising an inference that they might have been communicating with each other. There were several crimes over a period of time that strengthened that inference. And the court held that that was not enough to indicate that, to give the Commonwealth access to the phones. The fact that someone committed a crime, or that there's cause to believe that someone committed a crime, and that person owned a phone, should not be enough. It should not be enough just on the very face of 2703D. That the information sought, there must be information given, that the records that are sought are relevant and material. So there wasn't even not even an attempt in this case to show that the records were relevant and material. I'd ask the court to, I know the court was discussing Fulgham earlier. In Fulgham, there is a discussion concerning 2703D and the adequacy of 2703D. In that particular case, in the application, there was information that the defendant and the victim had been in telephonic communication immediately before the crime. So clearly, that was an attempt to connect the telephones to the crime. There's no nexus here between the telephones and the crimes, and that's required even under the lesser standard of 2703D. I'm asking the court, of course, also to consider the giving of an instruction without objection on the issue of transferred intent in this case. And specifically, I'd ask the court to note the type of instruction that was given, to focus on how exactly the judge defined transferred intent.
How should the judge have answered the question in your view?
The judge, because there wasn't enough evidence to support transferred intent, the judge should have answered the question by saying, the issue is not before you. Please decide this case based on the instructions I would have given you. I'd suggest to the court...
multiple people on a porch, as I remember it, and the victim comes up to the vehicle, and the jury could have been saying, well, maybe he had a beef with someone else.
Well, the jury could say maybe he had a beef with somebody else. The jury could speculate about that, but there was no evidence of that. And I'd ask the court, there's actually a dispute between the defendant and the Commonwealth about what the evidence shows. At volume 1 from page 200 to 204, we're both referring to the same evidence. If you look at that, you can see that at the time of the actual shooting, this is the second pass of the car. At the time of the actual shooting, the only people there were the victim, Mr. Suarez, the witness, and his cousin Joey. And there's absolutely nothing anywhere in any of those pages to indicate that the shooter had any argument or any kind of a dispute with any of those people.
But there's the testimony from that the victim goes up to him and says, "It's me, your brother, right?
Yes.
JM," meaning that, you're not mad, meaning he's mad at somebody besides the person trying to de-escalate the conflict. And people keep referencing that the victim is trying to de-escalate. So doesn't that suggest that the beef is with somebody else?
Well, that certainly wasn't the way the judge understood it before this question suddenly popped up. This wasn't the way the defense attorney or the prosecutor understood it until we had this very speculative question that came from the jury.
Was the instruction that Judge Welch gave legally wrong?
I'm sorry, Your Honor.
Was it legally wrong? Did he give an accurate transfer intent? You just said it was not applicable.
It was not applicable. I'd suggest another example. If the jurors had asked, Your Honor, what about self-defense here? After all, there was a knife, a closed knife, found next to the victim's hand. There was very close contact between the shooter. What if the jurors had popped up with, Judge, what about self-defense? Surely everybody would agree that that was no ground for the judge to suddenly inject, after the jurors have retired to deliberate, on self-defense.
Of course, judges want to answer jurors' questions, but your position is the judge says, that's not before you, go back to your deliberations. I can't answer that.
I think it would be exactly the same situation. If the jurors came up with a question that was based on speculation, not based on the evidence in the case, then the correct response isn't to add a defense or to add a theory of guilt.
Sure, if someone was killed with a single gunshot and there was, or something, you wouldn't give a speculative atrocity cruelty instruction. You wouldn't give a self-defense instruction, like you said, absent some predicate facts, correct? But here, there is evidence of a somewhat friendly relationship, and the person's shot who's trying to de-escalate, and this person's doing a drive-by for some reason because he's mad at somebody.
Well, it's not, if you look at the closing arguments, that's not the way anybody interpreted this. Everybody interpreted this as a beef with Julian. And
But that was the evidence, right? So maybe apparently the jury interpreted it that way.
Well, clearly there was some speculation by the jury about
Based on the evidence that they heard about the victim.
Your
and
Honor,
what the victim said.
that the victim, because
I understand
this
that
was
that's not your...
interpreted by, I'm sorry, Your
No,
Honor.
no, no, go ahead.
This was interpreted by the witness who testified, the statement by Julian. It's me, Julian, your brother. It was interpreted as trying to calm the shooter down. Certainly, it could be viewed as come on, we're friends. What are you doing? And it certainly appears as if this is exactly how everybody there looked at this, until the jurors came up with a speculative idea. One juror, more than one jury, we don't know. But there was this apparent speculation.
I don't know.
I'm sorry, go ahead.
I just don't understand what you're saying there. It sounds like you're saying the same thing we are, which is he was trying to de-escalate. You know me, I'm your friend, I'm your brother.
Yes, but there was no evidence there that the shooter had a beef with anybody who was present at the time of the shooting other than Julian. He put the gun right up to Julian's neck. The shooter shot him right in the neck at close range. There was no evidence that anyone was in the line of fire, anyone else was in the line of fire, anyone else was near the line of fire. And this is why nobody thought of it until we got this odd question from the jurors.
So let's assume that there's one juror in the jury room who says, I'm not so sure that he intended to kill Julian. Maybe he was seeking to kill somebody else, or maybe he confused Julian with somebody else, and that's why Julian was trying to tell him it's me. I would like to know whether that matters. And this question comes, and the judge says essentially, no, it doesn't matter. As long as he intends to kill, it doesn't matter whether he intended to kill the victim. Where's the injustice? Where's the miscarriage of justice that arises from that instruction?
Well, the miscarriage of justice is there because it is just speculation by the juror or jurors, unsupported by any evidence in the case. If there had been evidence of transferred intent of the type that the judge instructed on, that the defendant was intending to kill X and instead killed Y by accident, that's what the judge instructed. And there was absolutely no evidence in this case that was what happened here. So when the jurors ask a question that's based on mere speculation, that doesn't call upon the judge to kind of encourage that by instructing on something that's not supported by the evidence.
But we don't tell juries they must be unanimous as to who the defendant intended to kill, do we? If there is uncertainty, if there's a question of whether or not he meant to kill him or meant to kill the person behind him, the jury could be divided and still find the person guilty.
Your Honor, this case was tried on one theory, that the defendant intended to kill that the defendant intended to kill Julian Melendez. It's not like Taylor, as the Commonwealth has said. It's not a question of there being a target group of people that the shooter could have been angry at. There was absolutely no evidence that of the 3 people who remained in that area at the time of the shooting, the shooter was involved in any kind of a conflict with any of the other people who were there at that time. This was entirely speculative and unfair. Just as unfair as if the judge had added a self-defense instruction based on speculation by the jury. Anybody would agree that that would have been grossly unfair to the Commonwealth, just as this was grossly unfair to the defendant, and he should have a new trial. Thank you, Your Honors.
Thank you.
Mr. O'Sullivan?
Good morning. May it please the court. David O'Sullivan for the Commonwealth. I'll begin with the transferred intent issue. At the outset, to clear out the factual dispute between my sister and I with regard to what the evidence shows as to who was present on the defendant's second pass with his car into the area. While Santos Suarez testified on his first day of testimony that those present at the time of that second pass were himself, the victim Julian Melendez, and his cousin Mr. Mendez. On his second day of testimony, at pages 27 and 28 of volume 2 of the transcript, he testifies explicitly that others who were there on the defendant's first pass in the area, that is Fausto Diddy Gonzalez and Carlos Benau de la Cruz, were also there when the shooting occurred, quote unquote. And that's again page 27, 26 through 27 of volume 2 of the transcript. So in that second pass, and it's clear the jury, their question was prompted by this, you had people on scene with whom the defendant had been arguing during his first pass and continued to argue with during the second pass. A reasonable view of the evidence permitted the inference that it was not the victim, Mr. Melendez, with whom the defendant was arguing, and the beef, so to speak, was not with him, but instead with others on the scene. And the jury's question showed a clear focus on that evidence and was well-founded when they said, does it matter whether the defendant necessarily meant to shoot the victim or if he meant to shoot someone else? What does that matter? And the judge gave a perfectly appropriate instruction on the concept of transferred intent, which is legally completely correct, as my sister acknowledges. And the jury returned a verdict that was consistent with the evidence. To address what I think Chief Justice Gantz's question was getting at with respect to whether the jury need be unanimous on the theory as to whether it was based on transferred intent or intent to kill the intended victim. I would submit that I don't believe this court has ever ruled explicitly that it's the case that jurors are required, or that a defense is required to specific unanimity with respect to those different theories. I would submit that the court has time and again said that with respect to theories under which, or alternative theories that to prove the same element, the jury need not be unanimous. That includes principal and joint venture liability. That includes, for example, in a second-degree murder case, the particular form of malice that the jury has to find. They need not agree on whether it's first, second, or third prong. And of course, in the Cunin circumstance, this court has termed it a mere evidentiary consideration, which particular Cunin factor the jury finds, and they need not be unanimous on that. These are alternative means of proving the same thing. And as this court's cases have made clear, it doesn't matter if the defendant's intent was to kill the victim, Mr. Melendez, or someone else on scene with whom he may have been having a beef. The defendant's mens rea would be the same, and the defendant's acts would be the same that would lead to his conviction. Now, with respect to the issue of the 2703D order, the Fulgium case that my sister brought to the court's attention via a 16L letter, and it was much discussed today, although different parts of it, is supportive of the Commonwealth's position here with respect to whether probable cause standard, whether essentially she was entitled to, Mr. Vazquez was entitled to the benefit of the Augustine 1 decision, or whether we judge the effectiveness in accordance with prevailing professional norms at the time. At the time, it was perfectly appropriate for an officer to obtain through a 2703D order CSLI, particularly where only 24 hours was sought in this case. In the Fulgham case, it was 11 days of CSLI that was sought at a roughly similar time, and there was August 2011. And the court considered there, much like here, direct appeal claim of ineffective assistance for failing to move to suppress that. And the court's analysis was straightforward. It said, you didn't raise the issue of the probable cause requirement below, so you're not entitled to the benefit of Augustine, because you need to prove.
Doesn't Broom complicate that a little bit? Footnote 9. I'm actually confused a little bit by this. Broom says you should have. Broom says there was enough of this going on at the time that you should have been aware of this stuff, right?
Right.
So doesn't that suggest that you are ineffective if you've waived the issue?
Well, what the footnote in Broom.
And then you go one step further and sort of identify a gap between ineffective and failing to waive. Very creative. It makes me nervous that we're in sort of a lack of.
Right. Well, it had to do with
clarity
the clairvoyance exception to the waiver doctrine, and the clairvoyance exception to this is.
But let me just make sure I understand your argument. You're saying that even though we say in Broom that you should have been making this argument, Broom doesn't go the next step and deal the ineffective analysis. Your sister has raised the ineffective. You say you can fail to waive it but not be ineffective.
Correct.
And
So what Broom addressed, what that footnote in Broom addressed, was the clairvoyance exception to the waiver rule. And in that case, what that exception to the waiver rule is that counsel need not be clairvoyant. If the theory on which the argument is based is not sufficiently developed at the time, you can't be held to have waived it.
Then they find that it was sufficiently developed.
Then they find that it was sufficiently developed such that the clairvoyance exception to waiver doesn't apply.
Right, but
that does not mean.
But doesn't that lead to then you're ineffective for not having raised it, given that you should have realized that?
No, for several reasons. And although, as the court points out in its Broom footnote, in the footnote in Broom, there were issues percolating in the lower courts and in some appellate courts across the country about the privacy interests implicated by CSLI technology. And there were some decisions that suggested that a warrant was required because this is akin to tracking a defendant's movements. But there was no. Obviously, Augustine wasn't for more than a year later, and obviously Easterbrook was even further after that, which drew the constitutional line at the 6 hours.
But you're basically saying generally that you can not have raised it and still not be ineffective.
Absolutely correct, Your Honor, and that's particularly so with respect to the amount of time that was sought here. The theory of suppression in all these cases is that mosaic theory of the Fourth Amendment, which is that over time, tracking technology reveals the pattern of your life. With respect to the 2 weeks in Augustine, the court ruled that was the case. We quote that portion of the court's opinion, at least with respect to 2 weeks. This is akin to tracking a defendant's movements, like GPS, such that the pattern of one's life is revealed in which the defendant has a privacy interest. Where we're talking about 24 hours, we are talking about a very different period of time. And counsel would have little cause to believe in 2010 to 2011 that CSLI obtained with judicial leave through a 2703D order, albeit on the lesser standard, was unconstitutional under Article 14. I would say it's a very different question, although the lines are somewhat blurred.
Isn't it particularly okay here because you've got so much evidence to support? I mean, you have probable cause evidence. You don't, even if you're meeting the lower standard, you have the higher standard of evidence, right?
Correct. With respect to the data or the information in the 2703D order, I would submit that we clearly have probable cause, not just, the reasonable ground standard of 2703D, where we have a named informant who
I'm
relays.
just more focused on the next case where you've identified this middle ground between ineffectiveness and failing to waive, and it seems complicated, but anyway, you've done a very good job of it, but.
Well,
yeah.
I would note another point, and that is that in Broome, it was 11 days of CSLI that was sought.
Right.
Augustine, 2 weeks. The 24 hours here is far closer to the Easterbrook line of 6 hours. And of course, in the trial, if we're talking about a substantial likelihood of miscarriage of justice, only 30 minutes of the most relevant data was actually used, and the court found that there was a month, I believe, the full amount was admitted in the Broome case, but they used a much smaller portion, and this court found that relevant to the issue of whether there's a substantial likelihood of miscarriage of justice, and the amount used in this case was well below what the court found would be.
Remind me of the holding in Easterbrook. Easterbrook holds what? That I understand it's a lesser time, but it still says you need probable cause, right? Or
it does. What the court did in Easterbrook in 2015 is it ratified Note 37 of Augustine 1, in which the court said in dicta that this is not the case in which to draw the constitutional line of when you need a warrant versus when a 2703D is sufficient. But we say, that 6 hours seems like a reasonable time in which to draw that line. And that footnote was sort of ratified and became the law of Article 14 in that Easterbrook case. And that was, again, years after that, fully 5 years after the time when this was actually obtained by the defendant, or by the Commonwealth, by the trooper in this case. And it was a reasonable view of the evidence that what he was doing was perfectly appropriate, certainly under the law at the time, and counsel were not ineffective, both counsel were not ineffective in failing to push for, in these factual circumstances, a ruling like that that would later come in Augustine. It would have been a much better claim in the Fulgium case, because I believe 11 days was sought there as well, if I'm not mistaken. I could be wrong. It was far more than what was obtained here. So I would submit that counsel was not ineffective in obtaining, in not moving to suppress that, given that the 2703D order was appropriate. If there are no further questions about that or any of the other issues raised, I would rest on my brief.
Okay, thank you. We'll take a morning break.